Hi, everybody. My name is Jennifer Sugarman. I'm the president and CEO of the Cocoa Beach Regional Chamber of Commerce, and I'd like to welcome everyone to this awesome webinar we are doing with our partners at Volk Law Offices. We have Barry Baker today with us, who's going to be going over this very important topic and sharing his screen. Please feel free to ask questions in the chat and we will get to them as soon as we can. Probably we'll save some time at the end. This will be recorded, so I encourage you, once you see it pushed out from the chamber and from Volk, that you share that as well. So with that, I just wanted to say hello and a quick welcome, and welcome Barry to present on this important topic. Hi, Barry, how are you?
Okay, thanks, Jen. I'm doing fine.
Good.
Yeah, I'd like to thank the Chamber for the opportunity to speak today. I think the Chamber, and we can all agree that the Chamber has been a tremendous resource during the COVID-19 pandemic, while struggling itself to adapt to the environment, and has been a tremendous help to a lot of the local businesses. So today, I'd like to be giving you an overview of several evolving legal issues related to the COVID-19 pandemic that continue to evolve daily, and some of the executive orders that have been issued by the incoming administration that may have a material impact on employers in the coming months and year. So because we're covering a lot of material today, if I do not get to your question today, I want you to feel free to email me at the email address that's on the screen of bbaker@volklawoffices.com. And if you have any questions about the materials, I'll be sure and answer those, and Jen or Darlene can share those questions and answers with all the participants after the seminar is concluded. So all of you know that lawyers are big on legal disclaimers, and that's especially true when it comes to employment law because it's an extremely broad area of practice. And one of my old contracts professors from law school, and this is something that's always stuck with me, he used to always say that a shot glass full of facts is worth a tub of law. And what that means is we can know everything there is to know about the law in theory, but unless we've done a detailed factual review and researched your individual situation to see how those facts fit into that law, we can't render a legal opinion. So also a legal opinion would include factors such as the type of employer, the number of employees that you have, and that will determine whether or not some of these employment laws even apply to you. And some of you may have federal contracts involved in your business, as well as a portion of your workforce. It's not as prominent in the South as it is in the Northeast or other areas of the country, but we still do have our employers that have some unionized employees. And the answer to any legal question would require referencing the collective bargaining agreement, see how that impacts it. So over the past several months, all of us have become more familiar than we wanted to with the Families First Coronavirus Relief Act and the paid sick leave and emergency expanded family medical leave that were required by that act. So that act was in effect from April 1st, 2020 through December 31, 2020. And under that new law, as many of you are already aware, employers were required to provide up to 80 hours of paid sick leave to employees who were struggling with the COVID-19 virus directly. Either they had contracted it, or they'd been in close contact, or they had symptoms and were seeking a diagnosis, or they were taking care of somebody that had COVID-19. The law also provided for emergency family medical leave for a covered employee to take up to 12 weeks of job protected leave where they were unable to work or telework because they needed to take care of a minor child, a son or daughter, due to the closure of normally schools or their normal childcare arrangements due to COVID-19. So those new leave requirements expired December 31, 2020, and there is no longer any legal requirement to provide those types of leave. However, in the latest stimulus package, there's a provision that provides that an employer can continue to voluntarily provide these benefits and claim a refundable dollar-for-dollar payroll tax credit for the cost of the leave through the first quarter of 2021, or March 31, 2021. So even though it's not legally required, and even though the government is making it easier to provide this leave voluntarily with the refundable tax credit, the main practical consideration of thinking about providing this voluntarily is that if an employee knows that they're not going to be penalized for disclosing a diagnosis or symptoms or close contact, they're less likely to cover those circumstances and bring the virus into your workplace and the resulting lack of productivity and the disruption to your business. So that's just a practical consideration that I like to remind employers of, that even though they're not required to provide it now, just from a practical standpoint, they may want to consider voluntarily extending it. So even though the legal requirement ended on December 31, 2020, there is still liability for employers for requested leave before December 31, 2020 that was not provided. And the statute of limitations, that is the time period that they have to bring a individual lawsuit, is 2 years in most circumstances and 3 years for a deliberate violation. So this includes not only an individual lawsuit, but an audit by the Department of Labor, normally which are instigated by a complaint from a disgruntled employee. So those of you that, I know we have a lot of small businesses in the chamber, but some may have already been covered by the normal FMLA or Family Medical Leave Act. And it's important to point out that even though these two new leave laws, you don't have to pay for them anymore, if an employee has COVID-19, it's likely going to be categorized as a serious health condition, and that employee would still be eligible for their normal FMLA leave up to the 12 weeks of unpaid leave that they're entitled to, assuming there's a covered employer and a covered employee. So this is the status of the law right now. But as everyone knows, there's a new administration in town, and they've indicated that big changes may be coming. And I was discussing this with Jen and Darlene prior to beginning this webinar. It's a lot to keep track of. It's evolving daily. So it's important to keep on board and up to date with this. So President Biden has an American Rescue Plan that he has published, which among other items calls for additional paid leave. The plan calls for legislation to provide the following. It's going to extend the Families First Coronavirus Response Act and emergency paid leave measures through September 30, 2021. Again, this has not been put into effect. There's no details. This is just basically an executive order, is an administration saying, this is what we want to do, and we're directing the Department of Labor to look into this. They're going to eliminate the exemptions under the FFCRA for employers with more than 500 employees and less than 50. And under the old law, it only applied to employers with less than 500 employees and allowed a small employer to claim an exemption if they met certain statutory criteria when the imposition of such requirements would jeopardize the viability of the business as a going concern. So this executive order basically covers all employers, and it removes the exemptions for small employers who otherwise would have been exempted from the paid leave requirements. So it could potentially be a big impact, especially we're still in the middle of a pandemic. We still got a lot of businesses that are shut down. Fortunately, in Florida, we're a bit more wide open than other states, but this could be an incredible burden on a already struggling small business that's subjected to these paid leave requirements without any exemptions available. So it's just something to keep track of. So this plan also provides for 14 weeks of paid sick family and medical leave to, quote, help parents with additional caregiving responsibilities when a child or loved one's school or care center is closed. So it's the same, basically the same requirements as the former law. And for people who have or are caring for people with COVID-19 symptoms or who are quarantining due to exposure. And that's basically the emergency paid sick leave under the former law. How that 14 weeks is going to be apportioned, don't know. There's no guidance on that yet. But again, that's something that should be unfolding in the coming weeks and months. So again, making this law even more inclusive, formerly exempted, now it's going to extend to federal workers. And it also removes the former exemptions for healthcare workers and first responders. Formerly, they weren't entitled to this leave. And again, it's really broadening the scope by basically eliminating all of the exemptions and making it applicable to all employers. Also, a maximum paid leave benefit of $1,400 per week for eligible workers. Employers with less than 500 workers could be reimbursed for the cost of this leave. How that's going to work, again, we don't know. But under the old law, the max benefits were $511 a day or $5,110 over 10 days for the emergency paid sick leave. So details are not available yet, but we're going to have to keep monitoring this and see what the Department of Labor issues in the coming weeks. So at last count, the Biden administration had issued 19 executive orders. That was as of yesterday. There may be more today. I haven't been watching the news today, but likely going to be more. So one of them directs the Department of Labor through Osha. Now, the Occupational Safety Health Agency or Administration is underneath the Department of Labor, but the executive order directs the DOL to issue revised guidance to employers. I'm not sure what this means, quite frankly, because Osha has been regularly updating their compliance guidance. And if you have not, I would highly recommend that you go to osha.gov and click on the coronavirus resources page link. Most of you have already done this, but it provides a wealth of information and guidance, and it's updated at least weekly. And it's really the source of information for complying with OSHA requirements, including workers' rights, preparing the workspace, and returning to work guidance. So I'm not sure that in 2 weeks, the Department of Labor is going to be issuing any significant change to what OSHA is already doing. Again, executive order, it sounds good in principle, but the practical impact of that aspect of it, I'm not sure is going to be very much. But what is of potentially more significance is this emergency temporary standard that could be issued regarding the wearing of masks in the workplace. You should already be following all CDC guidelines. That's the reasonable standard of care. If you're doing that and documenting it, you're going to be a long way towards protecting yourself from claims, including OSHA violations. But if this emergency temporary standard is issued, again, we don't know what it's going to look like. Violation of this standard could subject the employer to OSHA enforcement action. And it's being pushed through in record time. Normally, new standards for OSHA take years to draft, to review, public comments, implementation. So again, this is another example of the COVID pandemic pushing regulations through in record time with some unintended consequences. Also, to the extent any standard is issued, it's going to be subject to review by the courts. And the courts in the past have frequently struck down these types of standards. And of particular concern to me and to employers is this last provision. It's launching a national program focused on the enforcement efforts related to COVID-19 violations, including retaliation. I'm going to cover in more detail later in the presentation about when a worker, for instance, can refuse to come into work. But what this executive order line item means is that there's going to be increased funding for enforcement efforts, and that means more investigations. So from whitehouse.gov, and I have to read this so it gives you a sense of where they're going here. As one of many measures to help keep workers and their families safe throughout the pandemic, the president is asking the Department of Labor to consider clarifying that workers have a federally guaranteed right to refuse employment that will jeopardize their health. And if they do so, they will still qualify for unemployment insurance, or what we call in Florida, reemployment assistance. So this one's curious to me as well, because under the general duty clause of the Occupational Safety and Health Act, employers are already required to provide a place of employment free from recognized hazards that are causing or are likely to cause death or serious physical harm to an employee. And under OSHA, an employee already has a legal right to refuse to work in such a workplace and is protected from retaliation from making a complaint. Therefore, there already is a federally guaranteed right. So I'm not sure what this executive order is expecting the Department of Labor to do differently, but again, it sounds good. So from a practical standpoint, The federal government may mandate a more lenient standard than Florida's for an employee to qualify for unemployment when refusing to come into the workplace due to COVID-19 concerns. And as it stands now, as many of you know, the Florida Department of Economic Opportunity is the agency in Florida that administers the reemployment assistance program. And their current guidance states that an individual with a general concern about COVID-19 exposure will not normally qualify for reemployment benefits if that individual has failed without good cause to accept a suitable offer of employment. And in that system, the employee that does refuse to come in due to COVID concerns has to report that as a condition of continued benefits. And the DEO has stated that each one of those cases is going to be evaluated based on the particular facts of that case. And obviously, to the extent the federal government is providing the pandemic-related unemployment assistance, they're certainly free to provide a lower standard for qualifying for those benefits than the state. So it's another one you have to stay tuned for. So before I get into the COVID-19 vaccination issues, let's review what an employer today is permitted to do under current EEOC guidance. And again, many of you already know this, but if an employee calls in sick, you can ask the employee if they are experiencing symptoms. Such inquiries are permitted under the Americans with Disabilities Act. And again, coverage under the ADA extends to any employer that has 15 or more employees in 20 or more consecutive calendar weeks in a year. But this type of question to them, if they've got symptoms, is not deemed disability related and is permitted under the ADA. You can require a negative test before returning to work. Follow the CDC guidance. I'm going to be saying that several times through this seminar today. But that is the objective standard of care now, is the CDC guidelines. You cannot use the antibody test though. So the negative test is not, it's deemed that a mandatory medical test of an employee, this type of test, is job related and consistent with business necessity. So applying this standard to the current pandemic, and this is under the ADA again, employers may take screening steps to determine if employees entering the workplace have COVID-19 because an individual with the virus, and this is a buzz phrase, will pose a direct threat to the health of others. And the EEOC has specifically stated that the ADA does not interfere with employers following recommendations of the CDC regarding whether, when, and for whom testing or other screening is appropriate. And testing meets the business necessity requirement under the ADA. But you cannot use the antibody test. That constitutes a medical examination under the ADA, and it really only tests for past infection. It doesn't test for an active virus. So it's deemed a medical examination and off limits as a screening tool. You can require a fitness for duty note from a doctor prior to returning to work. And of course, you can take the temperature of employees before allowing them into workplace. So when you're taking the temperature, for those of you that are doing it, it's kind of a pass or go, or a pass or stop type test. You're not storing the temperature data. But to the extent that it is stored, relevant to a particular employee, that's considered medical information and confidential under the ADA. So the COVID-19 vaccines, the Pfizer vaccine and the Moderna vaccines have begun rolling out, and the impacts on the workplace of these vaccines are starting to be considered by employers. This is all evolving, and also employment law attorneys that advise employers and HR professionals, of course. So let's talk about some central issues. The first one is, from a big picture standpoint, it's not settled at this point what the effectiveness of the vaccines is going to be in terms of protecting against the contraction of the disease, of the virus in the first place, and also the transmission of it. And to the extent you do get the vaccine, how long and at what level is the immunity going to be for? The data is still out. We're still collecting that. So remember that the vaccines were issued under an emergency use authorization by the FDA. And to give you some context into what types of things are released under an EUA, The FDA allows the use of unapproved medical products in an emergency to diagnose, treat, or prevent serious or life-threatening diseases or conditions when certain statutory criteria have been met, including that there are no adequate approved and available alternatives. So they have not been formally approved or licensed by the FDA. And according to the latest article that I read, they're not expected to be formally approved or licensed for another 10 to 12 months. So when it comes to vaccinating your workforce before formal approval by the FDA, there's certainly no guarantee that a vaccine is going to be a cure-all, because the science just isn't there yet. The data isn't there yet. So the precautions that you're following now, according to current CDC guidelines, the social distancing, the masking, the separation of workstations, the hand sanitation or sanitizing, you're gonna have to continue to follow those until the effectiveness of this vaccine is more established. So a recent Gallup poll in December revealed that 63% of those polled were willing to undergo the vaccination. So you may want to consider an anonymous survey of your workforce just to get an idea of what percentage of your workforce is willing to take the vaccine voluntarily. You should also consider offering an incentive to boost the number of employees taking the vaccine. So one of the easiest ways to incentivize employees is to educate them. There's at a certain level and among certain employees or the population in general, there's a general distrust and an apprehension about the vaccine in terms of its safety. So a simple educational training session about the clinical trials that have been administered by both Pfizer and Moderna, and the extremely low incidence of complications related to, or adverse reactions related to the vaccine. It's extremely, the last one data that I looked at was 0.2%. And even of that 0.2%, some of the actual causes, that is whether or not the vaccine caused it, was still in question. So it's an extremely low complication rate with the vaccines that are out there now. So some of the other types of incentives that you could offer, you could make the vaccine available at the work site for free during paid time, or paying for time off and expenses associated with the vaccination. The law is in flux. The EEOC guidance is very much in flux right now when it comes to doing this type of thing. But Dollar General, Trader Joe's, and Aldi are all offering their employees pay incentives. And the incentives are ranging from 2 hours of pay for the vaccine to a $25 gift card. So before implementing an incentive program, you should consult with legal counsel to ensure it's compatible with the ADA and other anti-discrimination laws. And how, you may wonder, well, how does the ADA get implicated in an incentive program to get the vaccine? Just reading up on some EEO guidance this morning, if an incentive is offered as part of a wellness program, a person with a disability may feel compelled to disclose their disability that prohibits them from receiving the vaccine. And that could involve offering these employees a way to get around that. Is you could offer the employees the same incentive by doing something else. And what they've suggested is watching a COVID-19 precaution video or something like that. But when you get into the incentives, the higher the incentive, the higher the risk for the employer. And that's why it's important to consult with legal counsel before you implement one. And the EEOC actually had a rule earlier this year that, like a lot of other rules, was put on hold with the incoming administration, that gave an example of the incentives being limited to a water bottle. But that rule was withdrawn. So it's, again, this is something else that's evolving, and I'm keeping an eye on it, and employers should keep an eye on it before implementing an incentive program. So for now, my advice to employers, because the vaccines are not formally approved, is to simply encourage a voluntary vaccination of your workforce until we get more data regarding the effectiveness of the vaccine. So mandatory COVID-19 vaccinations. If you do decide to go forward with mandatory vaccination programs, even healthcare systems in Florida, as of today, are not implementing mandatory vaccine programs for COVID-19. If that could kind of guide you in where we're at right now in terms of a private sector employer with non-healthcare workers implementing a mandatory program. But if you do, is it necessary that one of the questions you have to ask yourself, is it necessary for the program to be company-wide? That is, you can, and this is permitted under the ADA, you can select certain employees, for instance, that work in close proximity with each other. I did a seminar similar to this last week to the Manufacturers Association, Space Coast, and a lot of those companies, they have workstations that's based on the machinery that's on the floor, and it's kind of hard to retool all that. So they've got folks that are close together all the time. So you may select that group of employees for the mandatory vaccination program, where you would not mandate the vaccine for administrative people that work in their own office with a closed door, that are spread out from each other, that can work remotely. So it doesn't have to be company-wide. In a lot of cases, it shouldn't be company-wide. Now, one warning, and this may be a common sense notion to a lot of people, but sometimes common sense goes out the door when you're talking about the law. And you may think, well, my older workers, I've got right now the vaccine is being administered to those 65 or older. That's the priority, and folks with comorbidities. So you may say, well, because they're at higher risk, I'm going to mandate that all my older employees get vaccinated. You don't want to do that. That could set you up for a discrimination claim under the Age Discrimination and Employment Act, and be an unintended consequence of trying to be the good guy and being benevolent. So there are going to be objections to an employer's mandatory vaccination program, and how an employer deals with those objections is going to require a very careful approach. So there are basically two legally protected bases for an objection to the COVID-19 vaccine. One of those is based on a disability under the Americans with Disabilities Act, and also those based on a religious or a sincerely held belief under Title VII of the Civil Rights Act of 1964, and the Florida Civil Rights Act, which is patterned on Title VII. That's our state law here in Florida that governs anti-discrimination. And we're going to cover both of those. Again, before you implement a mandatory vaccine program, consult with legal counsel, because to do so will require compliance with these anti-discrimination laws. It's also to point out that in the latest stimulus package, there was a provision in it by Republicans that extended a liability protection to employers for discrimination claims in the administration of the vaccine. And that provision did not make its way through. So you may also have to abide, like I said before, every legal opinion is based on your particular facts, but if you have a collective bargaining agreement involved in your workforce, that's going to have to be consulted before implementing a mandatory program. So in addition to the Americans with Disabilities Act and the Florida Civil Rights Act, for those of you that have federal contracts in excess of $10,000, you're also going to be subject to the Rehabilitation Act of 1973, which has the same standards for evaluating a disability of an employee that the Americans with Disabilities Act does. So here are some examples of the basis of an employee's refusal to be vaccinated. An employee may have a diagnosed mental condition that causes severe anxiety with regard to vaccinations. This condition can be considered a disability if properly diagnosed and documented by a mental health provider. There's a case that I was reviewing last week that involved a hospital nurse that objected to the administration of a or actually it was a Tdap vaccine, tetanus, diphtheria, and pertussis, I believe. And she had a diagnosed anxiety of the side effects from this particular vaccine, and she had the medical documentation of it. She had a diagnosis of severe anxiety, and the court sided with her and found that that was a disability that had to be accommodated when it came to the administration of a vaccine. So same thing for a physiological reaction to vaccines, particularly an employee with a documented history of anaphylaxis. Most of you have heard about the cases in the UK during the point, I think it was in the first phase of the trials, where they had a couple of people that had severe reactions, but it turned out that they had well-documented medical histories involving anaphylactic shock. I think one of them actually carried an EpiPen on them, but that's an extreme example. But if you have somebody that comes to you and says, I can't get this vaccine because I have this condition, that's something that could be considered a disability and exempt them from the mandatory vaccine. So with regard to pregnancy, now this isn't a disability issue. This implicates another law. So according to the CDC, the safety of COVID-19 vaccines for pregnant women, again, this is another situation where the data is not clear. They don't know, really, because there hasn't been enough time and the limited data. So therefore, any employer should be very careful about taking any adverse employment action against a pregnant female that objects to the vaccine based on pregnancy. And even though, as I said before, it's not considered a disability, what it does implicate is the Pregnancy Discrimination Act, which is an amendment to Title VII of the Civil Rights Act 1964. And what that requires an employer to do is to treat a pregnant employee who's unable to work the same way that they treat someone with a condition that's not pregnancy is unable to work. So it has to be even-handed. So the EEOC, the Equal Employment Opportunity Commission, the federal agency charged with enforcement of employment laws, this is their current guidance with regard to the vaccines. First off, the EEOC has unequivocally expressed that if a vaccine is administered to an employee by an employer for protection against contracting COVID-19, the employer is not seeking information about an individual's impairments or current health status, and therefore it's not a medical examination. The reason that that's important is because there are very strict limits under the ADA when an employer can require a medical examination as a condition of employment. Prior to making a conditional job offer to an applicant, disability-related inquiries and medical examinations are generally prohibited. They are permitted between the time of the offer and when the applicant begins work, provided they are required for everyone in the same job category. Whenever I'm talking to employers about policies, I say, if you're going to do something, it has to be uniform and it has to be uniformly applied in most instances, so you don't set yourself up for these types of discrimination claims. So if everybody in the same job category, say they work on a manufacturing floor and they work on a particular assembly line of that manufacturing floor, all of those folks could have a different type of disability-related inquiry than other administrative folks, for instance. And once an employee begins work, any disability-related inquiries or medical exams, and this is a litigation breeder, but it's a key phrase under the ADA, the medical exams must be job-related and consistent with business necessity. Okay, what that means is determined on a case-by-case basis. The EEOC also points out that healthcare providers are going to be required to ask screening questions before they administer the vaccine, and those questions may elicit the disclosure of a disability. So, and the ADA prohibits those types of questions. So what the EEOC recommends is that the employer should have a third-party administrator conduct everything related to the administration of the vaccine. If the employer simply instructs employees to go to a local healthcare clinic or pharmacy of the employee's choice, it should simply ask for proof of vaccination. Okay, that avoids the employer asking any of these questions prior to them being vaccinated. But what happens when an employee does not provide the proof as requested? And that's where we start getting into these specific objections. So the employer can ask questions regarding why an employee did not receive a vaccination only if the inquiry is job-related and consistent with business necessity. But what does that mean? The EEOC stated that the inability to receive the vaccine must pose a significant risk of substantial harm to the health or safety of the individual or others. In other words, a direct threat must exist. And if a direct threat exists, then the employer must go through this interactive process to determine if a reasonable accommodation is available. So the EEOC considers 4 factors in this reasonable accommodation analysis: the duration of the risk, the nature and severity of the potential harm, the likelihood that the potential harm will occur, and the imminence of the potential harm. A direct threat is a determination that an unvaccinated individual will expose others to the virus at the workplace. Now, the EEOC has stated that this is not a one-size-fits-all analysis. It's based on the particular factors involved in the workplace or the particular employer. One of the considerations is based on the severity of a pandemic in the worker's location. For instance, there's a big difference between New York City and Minot, North Dakota, and that's going to be one thing that's going to be taken into account. The employee's own health and the employee's particular job duties. And a determination of a direct threat also would include the likelihood that an individual will be exposed to the virus at the work site. So measures that an employer is already taking in accordance with CDC and Osha guidance are relevant to this consideration, whether or not they present a direct threat. For instance, if you're taking all of the mandatory social distancing, the masking, the hand sanitizing, and the routine cleaning of frequently touched workspaces, that's going to be considered in this analysis, including alternate shifts. So reasonable accommodation, the factors to consider: if an employer determines that this employee cannot be vaccinated due to a disability, and they pose a direct threat, there's a lot of steps that have to be followed there before you get to this point. The employer cannot automatically exclude the employee from the workplace, nor can they, terminate their employment or take any other action unless there is no way to provide a reasonable accommodation that would eliminate or reduce the risk, such as performing the current position remotely. That's something we're all familiar with now. Alternating work hours or rearranging the workspace of the employee. So in determining what reasonable accommodation may be available or even required, you have to engage in this interactive process. Once the employee lets you know about a disability, or you otherwise find out about it, they voluntarily provide the information to you. You have to engage in this interactive process to determine if a reasonable accommodation is possible under the circumstances. And if an accommodation creates an undue hardship on the employer, it's not reasonable. That is a significant difficulty or expense. And again, that is determined on a case-by-case basis. And that's where experienced employment law counsel can help you in this determination. This process should include determining whether supporting documentation about the employee's disability is required. And one reference that most of you probably already know about this, that are covered by the ADA or the Rehab Act of 1973, but a reference that's referred to by both the EEOC and the Department of Labor is askjan.org. And this is the Job Accommodation Network. And this website, it's really got a lot of great resources that are specific to the COVID-19 reasonable accommodation issue. So if you click on the COVID-19 link on the homepage, it leads you to multiple resources and examples related to COVID-19. And using this resource, documenting your use of the resource, if it turns out that you're unable to provide a reasonable accommodation, if you can go back and show the EEOC or the court that you went through this process, you consulted with this objective standard or this resource of askjan.org, and it turned out that you weren't able to do it, that's going to go a long way towards helping to defend a liability claim based on a failure to provide a reasonable accommodation. Also, any of the information that you gather, any medical records, any questionnaires that are filled out by the employee, that is confidential medical information, and it has to be kept separately from the employee's general personnel file because it is considered medical information under the ADA. So what constitutes an undue hardship? And I have to read this because this is right from the statute and the regulations that interpret it. So an undue hardship, it's an undue hardship if it results in significant difficulty or expense for the employer, taking into account the nature and cost of the accommodation, the resources available to the employer, that is, the financial resources of the employer, are taken into account. It's one thing to be dealing with a mom and pop shop and another thing to be dealing with a Fortune 500 company, and the operation of the employer's business. If a particular accommodation results in an undue hardship, an employer is not required to provide it, but still must consider other accommodations that do not pose an undue hardship. So it's important to point out that you don't have to accept what the employee thinks is the reasonable accommodation. There may be another way to reasonably accommodate it, but you don't have to take what they're saying is the accommodation and implement it. Now, they are the best source of information. You should certainly consider it, but it's important to point out that you don't have to do whatever they're saying they need. I had a client call me the other day with an employee that was recently diagnosed with epilepsy, which prohibited them from driving to and from the workplace and out into the community, which is part of their job responsibilities. And the employee's suggested reasonable accommodation was an Uber. You call me an Uber wherever I need to go, to and from work, out in the community. I said, whoa, whoa, whoa. Okay, let's think about this a little bit more. Let's talk about public transportation. Let's talk about carpooling, maybe an Uber occasionally for specific types of community outreach that they were required to do. But just because they want the most expensive option doesn't mean that that's what you have to do. So while we're talking about asking employees questions about their medical conditions, I want to mention the Genetic Information Non-Discrimination Act, or GINA for short, which prohibits discrimination on the basis of genetic information with regard to health insurance and, in our context, employment. So GINA prohibits employers from asking employees medical questions about family members. And where this may come up is, where is the most likely source of a COVID infection? That's in their own household, their own family members. So it may be a natural question to ask, anybody in your family have COVID? Again, this is one of these perfectly common sense questions, but you can't do it under GINA, under this particular law. You can easily get around that by asking a more generalized question. Have you been in close contact with anyone diagnosed or with symptoms of COVID? And that'll cover your base, but you can't ask the particular question about family members under this law. So Title VII of the Civil Rights Act of 1964 and the FCRA, or the Florida Civil Rights Act, prohibit religious discrimination. So in addition to the ADA, an objection based on a disability, an employee may object on the basis of a religious belief, or a religion, or a sincerely held belief. And the EEOC guidance basically says that it doesn't have to be one of the mainstream religions or something that's known to the employer. It may be something unorthodox. And the EEOC guidance says you should assume, if somebody objects on the basis of a religious or sincerely held belief, that it's valid. Now, remember, the EEOC, their whole function is to prohibit discrimination, to enforce employment laws. You can, as an employer, if you've got any objective basis to doubt the sincerity of the belief, you can dive deeper into this and ask more questions of the employee. So, for example, some easy examples. Christian Scientists rely primarily on the power of prayer for healing. That's one of their main tenets, rather than modern medicine. That may be an objection. Objections may be made by Muslims to a vaccine if it contains pork-derived ingredients, although the manufacturers of both of these vaccines have stated that they do not. Objections made by Roman Catholics to a vaccine developed or tested using fetal cell lines. However, the Vatican, and this would be relevant in determining whether or not you have to accommodate this, the Vatican recently released a statement that where alternative vaccines are not available, it is morally acceptable to receive a COVID-19 vaccine. So these are some relatively straightforward objections, but it's much broader than that. Title VII defines a religious practice or belief as a moral or ethical belief as to what is right and wrong, which is sincerely held. So this broader standard, I'll give you an example. There's a case brought by the EEOC against Red Robin, the restaurant chain, and the employee refused to cover up tattoos on his arms. Now, Red Robin had a dress policy. No tattoos should be visible. And this plaintiff objected and said, look, my tattoos are in homage to the sun god Ra, okay, which is an ancient Egyptian god of the sun. And these tattoos are written in Coptic. And believe it or not, the court sided with the employee that this was a sincerely held belief. So it kind of gives you an example of how it's just not based on mainstream religions. It could be something entirely different and unfamiliar to you. Fortunately, that case was in the Western District of Washington State, which is in the Ninth Circuit, which is kind of a legal island unto itself, so it's an outlier. But there's also been another case that held that veganism was a sincerely held belief that justified the objection to a vaccine, and that was in the context of a flu vaccine. It's important to point out that the undue hardship for religious beliefs is a far lower standard than under the ADA. In other words, the employer doesn't have to go nearly as far to accommodate a religious belief as it does a disability. So for these religious beliefs, the standard is whether the accommodation causes more than a de minimis or a trivial cost to the employer. For example, in a lawsuit that was brought by, again, the EEOC against Rent-A-Center, there was a manager who was a Seventh-day Adventist who had repeatedly refused to work on Saturdays. And eventually Rent-A-Center terminated his employment. And the court sided with the employer, or Rent-A-Center in this case, because it looked at the factors that Rent-A-Center does most of their business over the weekend. The fact that the manager wasn't there on Saturdays lessened their ability to make more sales. It put more stress on other employees. It lowered employee morale, and it wasn't consistent with the business model of Rent-A-Center. So that was considered to be more than a de minimis effect or cost to the employer. And certainly in the context of a vaccine, we haven't seen this case yet, but if you have an employee that objects on the basis of a religious belief to a vaccine, where if they had the vaccine, they would not present a danger in the workplace, that's more than a trivial or de minimis cost to the employer. So it's just something to think about. I think plaintiffs are going to have a really hard time prevailing with these types of objections, but plaintiff lawyers are going to they're going to file these suits, no doubt. So what type of information can be requested? You can do an interview with the employee. You can request an affidavit. You can ask them to detail their firsthand experience, ask them to detail how long they've had the belief, examples of them exhibiting their sincere belief in it over a course of time and how they did that. You can talk to neighbors, co-workers, anybody else that's identified by the employee that could that they're alleging can substantiate their sincerely held belief, and you can get documents from them as well. So just like under the ADA, if an employee fails to engage in this interactive process with you and doesn't provide you the requested information, they could lose any subsequent claim that the employer improperly denied an accommodation. So that's why you have to engage in this interactive process and document it. And if they refuse to engage in it at all, that's going to work against them in any type of claim they bring. So briefly on the COVID-19 OSHA issues, there are still no specific standards covering COVID-19, but as I covered earlier, remember the executive order directed the Department of Labor to come out with more defined guidance. So we'll see where that goes in the next weeks or so. But until the specific standards come out, the general duty clause governs, which requires employers to furnish each worker employment and a place of employment which are free from recognized hazards that are causing or likely to cause death or serious physical harm. So a question that I get frequently, I don't get it so much anymore because I think most folks have figured this out by now, but when may an employee refuse to enter the workplace under OSHA regulations? So here is how OSHA describes the circumstances when a worker can refuse to come into work. If the condition clearly presents a risk of death or serious physical harm, there is not sufficient time for OSHA to inspect, and where possible, a worker has brought the condition to the attention of the employer, the worker may have a legal right to refuse to work in a situation in which he or she would be exposed to the hazard. So let's take an extreme example. Let's say you've got an employer that's obeying none of the CDC guidance, none of the OSHA guidance. They've got employees running around with COVID, diagnosed and coughing everywhere and working in close proximity with each other. The employer knows it and does nothing. That's an extreme example. Okay, that is a situation where an employee could refuse to come in. However, where an employer is abiding by all of the CDC guidance and the OSHA guidance, and there's no diagnosed cases or close contact, there's no specific threat in the workplace, an employee just simply cannot say, I'm not showing up because I have a generalized fear of contracting COVID. Now, we always got to be sensitive to somebody that may be claiming a disability, but in the vast majority of cases, an employee cannot simply just not show up for work. So what's the relationship of an available and approved vaccine to the general duty clause? And these are the factors. The last factor is where a vaccine may be relevant to an employer's general duty. We are not there yet at all. Like I say, we're probably out a year out from this point. But to the extent a vaccine becomes widely available, availability is the other side of it. And that goes back to a mandatory vaccination program. If you're going to mandate a vaccination program, the vaccine's got to be available. Otherwise, there's going to be nobody in your workplace. But with regard to the general duty clause, to the extent it's available, it's been proven effective, and you've got a certain situation where the vaccine would lessen the risk of the transmission of the virus to coworkers, that could be a situation where under the general duty clause, you may have a requirement to have that employee vaccinated. Workers' compensation issues. I have employers come to me all the time are asking me questions. Am I going to get sued in court by an employee because they've contracted COVID-19 in the workplace? Well, the general answer is no, because you have immunity. Employers have immunity under the workers' compensation statute, and that is their liability is limited to indemnity benefits and medical expenses under the statute. They're not subject to what we call a tort claim and negligence, where there can be compensatory damages and it goes to court as opposed to the compensation claim system. And the only way that an employee could, first of all, even to qualify for workers' compensation benefits, they're going to have to demonstrate that COVID-19 was contracted in the workplace as an occupational disease, which is going to be an incredibly high burden for an employee, because all of the contact tracing, they're going to have to eliminate all other sources of contracting the vaccine. It's going to be a tough one. And the only way that they can get around the workers' compensation immunity is if they can basically prove that the employer deliberately tried to injure the employee, or they engaged in conduct that was virtually certain to injure the employee. The cases are few and far in between where employees have succeeded on that argument. And especially with COVID-19, where you're going to have to prove the contact tracing and the causation element. And under that standard, they have to prove it by clear and convincing evidence rather than a preponderance of the evidence that is more likely than not. So that's going to be a tough claim to get around. There is a case that's pending down in Miami-Dade County, which shouldn't surprise a lot of you. And it's a wrongful death claim, and it's brought by the family of a Publix worker who back in March of 2020 was standing next to a fellow deli employee that was not wearing a mask and was coughing. He contracted the COVID-19 and later, unfortunately, died a couple of weeks later. That lawsuit's pending, and there's a motion to dismiss that is going to be heard in February. And a lot of plaintiffs' lawyers and defense lawyers are looking at that case to see what happens there. But again, I think those claims are going to be very difficult to prevail on. So liability issues, in addition to doing employment law, I also have many years of experience in defending liability claims or being involved in liability claims. So in addition to the workers' compensation claims, you may face liability claims from third parties, customers, vendors, suppliers, anybody else that's on your work in your workplace. And when a jury looks at these types of claims, in a negligence claim, for instance, the reasonable standard of care is, what would a person under the same circumstances be doing? What should they have done? And here, again, CDC guidelines, OSHA guidelines. If you're following those and you're documenting your compliance with that, it's going to go a long way towards defending these types of claims. And if you do that, the plaintiff's also going to have that additional causation issue, which is going to be difficult. And really, the types of businesses that I see this primarily affecting: wedding planners, special events, businesses that provide employees for these special events where you gather a bunch of people at once, and it's easy to track that event as a super spreader. Okay, and you have an employee that was there that had COVID. So that would make it easier, but still, it's going to be difficult to prove. I'll also mention briefly that there is a bill. It's a identical bill submitted in the House and the Senate in the Florida legislature that is designed to provide liability protections for employers. It has a relatively short 1-year statute of limitations to bring the lawsuit. It requires a showing of intentional conduct or gross negligence. It also requires the plaintiff to go out and find a physician who's willing to swear out an affidavit within a reasonable degree of medical certainty that this employee contracted COVID from your workplace. Good luck finding that doctor. They'll find some because they're basically going to be paid to do it. But that's going to be expensive and be a hurdle for a plaintiff from the outset. So I know we've covered a lot of material today. We're right at 1:01, so I'm pretty much on time, but some key takeaways that I want you to think about. First of all, with regard to the COVID vaccinations, the data is not in yet. The science is unsettled. So for now, I'm encouraging employers to simply encourage their employees to obtain the vaccine and incentivize it to make it easier or more appealing for the employees to receive it. Make sure you're accommodating those disability discrimination or the disability objections and the religious objections. Consult with legal counsel before you take any action terminating somebody's employment or determining that there is no reasonable accommodation. Protect against workers' compensation, OSHA investigations, and liability claims by abiding by the reasonable standard of care, which is the CDC guidelines and the OSHA guidelines, and document your compliance. And continue to monitor the Biden administration and the Department of Labor and OSHA and other federal agencies and the EEOC as these executive orders are, the concepts that are in them are tried, they attempt to put them in effect and the impact that may have on your workforce. So I hope the webinar has given you an awareness and some general information over all these evolving legal issues. As always, our firm is available to consult with you regarding virtually any business need, not only employment law. We can cover just about anything from business inception to dissolution to anything in between: contract litigation, contract drafting. We have board certified attorneys here, real estate, construction. Also like to add that the employment law services that I offer also include on-site training when we're able to do that again, or more particularized training for you based on your type of employer and your particular need. So with that, I'll throw it back to Jen. Thank you.
Thank you very much, Barry. That was awesome. I know I learned a lot as an employer, and I appreciate that. Is there anyone on the call still or the webinar that would like to ask a question directly to Barry? We just ask you to unmute and ask your question at this time.
Barry?
Hi, Donna.
Hi, yes, Donna from the Dinosaur Store. I had a question. It was kind of opposite to something that you referred to at the beginning of the presentation, where you talked about if you had an employee that refused to come to work. What if you have an employee that wants to come to work and you feel like, and this is off the job, let's say they have another job and they're exhibiting risky behavior? Is there, I mean, you know, that's their private stuff, what they're doing, but it's also well known to everybody. Is that just an individual case, or?
It is an individual case, but here's how you can handle that. Now, if you have an objective belief that an employee has been exposed to a much higher risk of contracting COVID, for instance, I've had employers contact me and say, hey, look, they're friends with so-and-so on Facebook, and you know, their Facebook post shows them at some type of rager, right? I mean, there's people everywhere right next to each other. If you have that belief, You can ask the screening questions, okay, about any symptoms, any contact, any situations where you've been in close contact with others. And then you can require a negative test if you need that. And it's based on a case-by-case basis, but it sounds to me like you have a situation where you know this person's been exposed to a lot more risk than the rest of us.
And here is the other thing. I just had a situation this last week where a employee was tested positive for COVID. Thank goodness they were off the 5 or 6 days before that, but they stayed at home. They were fairly severe, and then wanted to come to work and said, well, the doctor says I don't need the negative test anymore after 10 days. I talked to an epidemiologist of the Department of Health and 2 others. And even when you look on the CDC now, they're saying, oh, because they can have virus shed for over 30 days, they don't need that test. So, and I couldn't require a negative test based on, but everything I knew, and just, it killed me because I thought, oh my God, the rest of the employees were a little upset, but we all stayed distanced. Is that a thing now? I mean, you don't have to.
Yeah, that's another example of how the science has evolved over time. Before CDC did have in their guidance, they referenced a negative test before returning to the workplace.
Right.
Now they're saying, as you just stated, you can have the antibodies in your system, or the virus can be still shedding in your system and you not be contagious for several weeks after contracting.
Yes.
So their current guidance is 10 days after you tested positive. And if you're not exhibiting any symptoms, you haven't been in close contact, you remained in isolation, it's not, the CDC guidance is not requiring a test before coming back.
Right. And they added 24 hours just with no fever before you come in, 24 hours. No, you can't use Tylenol or whatever. And you actually can still you don't have to be 100% even. You don't, this is from an epidemiologist from Department of Health. You don't even have to be 100%. As long as you're feeling up 90, 95%, you're better.
Yeah,
10
and
days.
That's the science about how long after a positive diagnosis you remain contagious.
I hope they're right.
They're the experts, so we got to rely on them for now.
So anyhow, yeah, I thought I'd bring that up, and then, okay, the risky behavior is a thing that, yeah, it's touchy. It's touchy. Thank you. Thank you.
Sure thing.
Does anyone else have any questions before we wrap up? Okay. Well, thank you, Barry. You're a wealth of information. Oh, looks like I have one more.
Okay.
Go ahead and unmute and ask your question. Oh, don't have a mic. I'm happy to ask it for you. Go ahead with your question and I'll ask Barry for you. So we're following up on what Donna just asked. Can you still ask for the negative test as an employer?
I think the answer to that question is you can ask for a negative test, but if they come back positive and they've been beyond the time period the CDC is recommending that you're not contagious afterwards, you may need to require a doctor's note that even though this employee is testing positive, they're no longer contagious, and here's why. Okay.
Got it. That's good feedback. Thank you.
Okay.
Is there anyone else in the chat or otherwise that has a question for Barry? Okay, wonderful. Well, Barry, thank you so much for doing this. I know the businesses really appreciate it. The chamber appreciates it. Thank you for your partnership, and we will make sure that we get this recording out to all of those that could not join us today. So thanks everyone for being here. Thank you, Barry.
Thank you.
Thanks, Barry.
Bye-bye.